Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I'm Justice Shin. To my right is Justice Grant. To my left is Justice Smith, and we will be your panel for all 6 cases on the list today. As many of you know, the rules of oral argument are each side gets 15 minutes to argue. When the yellow light goes on, you should think about starting to wrap up. When the red light goes on, it means your time has expired, and we do not allow rebuttal in the Appeals Court. The last thing I will say is that you can be assured the panel has read the briefs carefully. We're aware of the facts, so I would urge you to get to the heart of your argument. All right, so with that, I'll call the first case, which is Commonwealth versus Orta, number 2023 P808.
If I may. Good morning, Your Honors. My name is Michael Maloney. I represent the appellant, Mr. Luis Orta. In April of 2018, the trial court judge erred when a guilty verdict was read at the bench trial of Mr. Orta. The Commonwealth failed to prove beyond a reasonable doubt that the defendant committed assault and battery with a dangerous weapon, to wit, a sandal. The dates of the occurrence were missing. The testimony by the only witness for the Commonwealth was void. Ignored the questions that were asked directly.
Sorry, you said it was void?
I'm sorry, sir?
The testimony was what, void?
The testimony of the alleged victim in this matter was void of descriptions as to how the bruises, the rug burn, if you will, and the other ailments that were visible on the picture had occurred. There was no description or pointing to my client as the individual that caused those. There was actually no testimony in regards to the dates that they were received as well. Specifically, when asked about the specific body part targeted, the respondent, the witness responded, "I can't answer that, I forgot," unquote. When asked, "Do you recognize these pictures?" These were the 3 pictures that were not corroborated as to when they were taken. The response was attributing the bruises to accidentally bumping into a wall, and the redness was supposed to be a rash caused by bed bugs.
If a witness says at one point the marks were caused by, in response to questions, were caused by objects being thrown at me, and one of the objects was a sandal, and then later when asked, more specifically, so the object was a sandal that was thrown at you, and he says, "I don't remember." Does that negate the previous testimony?
I certainly wouldn't say that it negates the testimony, Your Honor, but a motion for a directed verdict was requested by defense counsel at the close of the Commonwealth case. Under Lattimore, I'd say. Lattimore says outright that this cannot be based on a culmination of inferences. Sandal was referenced 3 times by the victim during the entirety of his testimony as prescribed by the transcripts. But not one of those times did he say, "This individual struck me." Not one of these times did he say, "It was thrown at me." It was more...
He said he grabbed something like harmful and hit us with it.
Would hit us with it. Yes, Your Honor. Your Honor, the allegation, this occurred over Memorial Day weekend from 5/26 through 5/30 of 2017. The testimony offered by the victim, I believe what Your Honor is referencing, was not in regards to that weekend. And again, I want to get there 2 separate issues that were referenced into the appellate's memorandum. Number 1, that reasonable doubt was not secured, that this did not happen based on the testimony relayed over Memorial Day weekend. Number 2, what I believe Your Honor just alluded to was the fact that this could also be, that the second argument for the appellant is that he had a parental right to discipline his child. When I believe the quote Your Honor just referenced was more given as a generality as opposed to the weekend specifically.
Commonwealth argues that that second issue is waived.
Because it wasn't proactively asserted by defense counsel. Your Honor, appellant's position is that this is a intrinsic constitutional parental right, not an affirmative defense that needs to be declared up front. I would also point out that for the first time during appeal, this is the first time that the prosecution has referenced the fact that this was not mentioned during the trial itself. I would suggest that the prosecution has waived that right by not declaring it during the trial.
Well, because the prosecution is saying it's an affirmative defense, right? So it's the defense's obligation to raise it.
Forgive me, Your Honor, could you please repeat that
The
question?
prosecution is saying it's the defense's obligation to raise it at trial. So you're saying it's not an affirmative defense?
Well, I'm saying that they didn't object at the time, Your Honor. They waived that right.
Well, they
They
didn't
waived-
object to the failure to raise an affirmative defense.
they
I mean,
didn't
either it's an
object at the time,
affirmative
Your Honor.
defense or not. So are you contesting that it's an affirmative defense?
Your Honor, yes, I am saying that it's not an affirmative defense. It is a right. It's a constitutional right to discipline one's child.
Aren't there cases that say it's an affirmative defense?
There are cases that support that it is an affirmative defense as well, Your Honor. Appellant's position right now, it is a constitutional right, intrinsic.
How did the Commonwealth know that it had the burden of proving, among other things, that the force was not reasonably related to the purpose of safeguarding or promoting the welfare of the minor? In other words, if this had been raised before trial as an affirmative defense, the prosecutor might have asked questions like, was there some danger? Was the child about to run into traffic or touch a hot stove? But without knowing that the affirmative defense has been raised, the prosecutor's not going to ask those questions.
Again, appellant's position is that this is a intrinsic constitutional right to discipline one's child within reasonable bounds, Your Honor.
So that the Commonwealth, in every case where there's a parent charged with assault and battery on their own child, the Commonwealth should always have to disprove parental discipline.
Your Honor, I wouldn't make a blanket statement to that degree, but the facts in this case specifically were over the Memorial Day weekend. During the course of Memorial Day weekend, the allegation was, to wit, a sandal was used as a dangerous weapon to assault his child Xavier. As the facts played out and as relayed by the alleged victim, in this matter specifically, there was no direct testimony that my client actually struck him during the Memorial Day weekend. Resultantly, appellant's position is that therefore the parental right, not the affirmative defense, is applicable. These bruises, as relayed by the victim, said that they were either a rug burn or I bumped into a wall, unquote. If these incidents are to be taken at their word by the victim, the Commonwealth's witness, if they didn't occur between the dates alleged, which I realize is not a deal breaker in and of itself, but if they didn't occur over the Memorial Day weekend, a reasonableness standard needs to be incorporated to determine when did they occur or did they exceed the bounds of reasonableness, Your Honors.
Setting aside the date, which isn't an element of the offense, you'd concede.
Yes, sir.
He was convicted of assault and battery with a dangerous weapon, to wit a sandal, correct?
Yes, sir.
Do you believe the evidence, I mean, a dangerous weapon could be a dangerous weapon per se, like a gun, or it could be anything that is used in a manner which could cause somebody a serious harm?
I would agree with that, sir.
Do you believe the Commonwealth met their burden of proof of establishing the sandal was a dangerous weapon in this case? Used as a dangerous weapon.
I appreciate that question, Your Honor. In this circumstance, defense would concede that a Commonwealth did show that a sandal could be used as a dangerous weapon. That, yes. Was there a follow-up to that question, sir?
No, well, yeah, actually, there is a follow-up, but I thought you'd give me a different answer. But the follow-up would be, if the dangerous weapon weren't proved, could the Commonwealth, or excuse me, could this court find a lesser included? There was evidence that the defendant admitted to tugging the ear. That evidence, I would say, was stronger than the evidence with the sandal. Would you agree?
Not necessarily, no, sir, I would not agree. I would say the photographs, again, which we're disputing when they were authenticated, when they were taken, but they did show some marks in the back of the shoulder, neck area, not so much near the ears, sir.
Multiple times during his direct testimony, he testified he would tug their ears, correct, the defendant?
That is accurate, sir.
And if that was sufficient for an assault and battery conviction, does this court have the authority to find the evidence was sufficient for assault and battery, but not assault, battery, dangerous weapon? What is your position on that?
Yes, the court would be operating within its discretion. Yes, Your Honor.
Do you know, as a matter of law, if a parent is allowed in Massachusetts to use a dangerous weapon in the course of parental discipline?
Your Honor, a dangerous weapon or a weapon in general. Your Honor, I've actually searched case law extensively. At this point, I believe it's still undecided case law in regards to whether an immaterial object could be utilized or could be fashioned with operating within the parameters of parental rights. I will say, however, on a fully clothed individual, that a belt thus far has been deemed to be operating within the bounds of a reasonableness.
So if a parent were to use a sandal to hit their child on fully clothed buttocks, in your view, would that be a dangerous weapon?
No, it would not, Your Honor.
Okay, so didn't the prosecution need to somehow tie the hitting with the sandal to photograph 3 or they had to show in some manner it was used dangerously, right?
Correct. It's appellant's position that they failed to do that, Your Honor.
Okay, so the evidence is not sufficient to show it was used as a dangerous weapon.
That is accurate.
Okay.
If there are no further questions?
No, I don't have any.
Okay.
Thank you, Your
We're
Honor.
all set. Thank you.
Good morning. Ellen Lazar for the Commonwealth. The Commonwealth asks this court to affirm the defendant's conviction because the evidence at trial supported it. To convict the defendant of assault and battery with a dangerous weapon, the Commonwealth was required to prove that the defendant intentionally touched the victim, however slightly, without right or excuse, with a dangerous weapon. Although the victim, who was 9 years old at the time of trial, clearly had some difficulty describing or recalling events, when viewed as a whole in the light most favorable to the Commonwealth, his testimony established that the defendant, his father, intentionally hit him with a sandal, where the victim was asked about marks or injuries depicted in Exhibit 3, which were 2 photographs. And the victim said, in essence, that sometimes his father would get angry and hit him with, quote-unquote, harmful objects.
Where did these photographs come from?
It's not clear where the photographs.
They came in without any information about who took them, when they were taken, right?
That's
so how
correct.
could the victim's testimony tie his injuries in the photographs to being hit with the sandal if there's no information about when these photos were even taken?
Well, the victim was asked what the photographs depicted and whether these were pictures of him, and he said that they were. And then when he was specifically asked about the photographs in Exhibit 3, he said, this right here. He kind of got mad, and he explicitly explains that the he to whom he's referring is his dad. He had earlier said that his dad was Louis Sorta. And then he said, sometimes if he got mad, he would grab something and hit us with it, like sandals and other harmful things.
And then he was asked, do you remember what part of your body he would hit you with the sandal with? He says, I can't answer that. I forgot. So what do we do with that?
Yes. Well, first of all, I would say where he hit him on his body isn't an element of the crime. And I would also say again
Don't you need to connect the hitting with the sandal to the injury in order to establish it was used as a dangerous weapon?
I would say 2 things. I would say, first of all, he is connecting it to what's depicted in Exhibit 3.
But
And
don't you have to connect it doesn't it matter what part of the body he was hit in order to establish the sandal was a dangerous weapon?
I think that the definition of a dangerous weapon is something, obviously, that's dangerous per se, or something that is capable of producing serious bodily harm. And so the Commonwealth was not required to prove that there was, in fact, serious bodily harm, but only that it was capable. And here, the images in Exhibit 3 are of his head and ear and neck area. So it's the Commonwealth's position that by the victim saying, in response to what's in Exhibit 3, this right here, sometimes he would get angry, he would grab harmful objects like sandals and hit us with them, that when all that is taken as a whole and viewed in the light most
Again,
favorable.
it matters what part of the body he was hit on, right? Would you agree that if a parent hits a child on the buttocks with a sandal, that is not enough to be a dangerous weapon?
Not always.
Okay.
I think depending on how hard the person was hit, whether it was over clothing or a diaper on bare skin, that it could be used as a dangerous weapon. But here, I would say, given, again, the location of the injuries depicted, that's on the head and neck and ear area, the fact that when asked about those images, the victim says, this right here. And then he says, he got mad, he grabs harmful objects like sandals, he hits us with harmful objects to harm us, that taken as a whole in the light most favorable to the Commonwealth, that this was enough to sustain the conviction. With regard to the parental discipline defense, it is the Commonwealth's position that the defendant waived this by failing to raise it below. It is absolutely clear that this is an affirmative defense that's been stated in multiple cases by this and the SJC. The SJC, in adopting the parental discipline defense in Dorville, explicitly stated that this would be an affirmative defense that the Commonwealth would not be required to disprove unless the defendant first raised it. And here, the defendant did not raise it. He denied disciplining his son at all, much less using any level of force, reasonable or otherwise, to discipline him. And there was no other evidence that supported that defense. So for that reason, the defense was never properly before the court, and the Commonwealth was not required to disprove it. If the court has no further questions, I would rest on my brief.
Yeah, I do have a question. I just want to see where you're referring to in the transcript about linking the sandal to the injuries.
Yes.
The young victim, I believe he's 10 years old at the time, when asked about the photographs, when asked about the redness in his ears, and I'm on page 18, the record appendix, question, and what about the one with the pictures of your ears? These are tugged ears. Okay, and the second picture, excuse me, what's that there? It's a rash, he says. He ties some other injuries to an accident and others to maybe bed bugs. I'm not seeing where you're linking the sandal to any photograph of an injury.
Yes, Your Honor. When he talks about the rash and the bed bugs and the bruise where he hit himself, that is explicitly when the prosecutor goes back and asks again about Exhibits 1, 2, and 4. If you look at transcript page 16, the prosecutor says, okay, so we're going to look at the third picture or the third page. What's that a picture of? And before that, sequentially, she had said, okay, first we're going to look at the first page of the photos, then the second page, and when they're admitted, they are admitted in that order. So it's Exhibit 3. She says, we're going to look at the third picture or the third page. What's that a picture of? This right here. He kind of got mad. Dad. Sometimes if we didn't listen, he'd grab something harmful and hit us with it. And then he goes on to say sometimes he'd grab things, that are harmful, and like sandals, and use that harmful object to harm us. So that's from pages 16 to 17.
I see that on 16, but unless I missed it, I think you skipped over when he said, I forgot, I can't answer that, in response to her asking about the third picture on the third page.
Yes, I mean, obviously, I'm presenting it a lot more fluidly than the way that it came out through the victim. But, I mean, when the prosecutor says the first question on page 16, so we're looking at the third picture or the third page, what's that a picture of? This right here, he kind of got mad, and I forgot. And then she says, when you say he, who is he, Dad? And then in the Commonwealth's view, the prosecutor follows up on what the victim had said about that photograph when he says this right here. I understand that in the middle he says quite a bit, I forgot, I can't say, I can't describe that. But again, it's the Commonwealth's view that if you view it all in the light most favorable to the Commonwealth, taking into account that this is a 9-year-old child testifying about something his father did to him when he was 8 years old, that there's enough to sustain the conviction. Thank you.
Thank you, counsel. The case is submitted. Next case is Commonwealth versus Charles Denning, number 2022 P1248. Whenever you're ready.
Just letting opposing counsel get settled. Good morning, Your Honors. Lisa Steele for Mr. Denning, who is present in the courtroom along with Ms. Lloyd Gemme. May it please the Court. The Commonwealth has conceded that it did not prove that Denning possessed any of the ammunition. If this Court accepts that concession, that just leaves us with the motion to suppress Detective Seidel's warrantless entry into the home. Now, we've got 3 distinct points in time that have been raised on the briefs. The first point in time is the initial entry. Detective Seidel claims an exigency, that the rifle in the foyer is intrinsically a threat to public safety and to the police. But he doesn't act like it's an exigency. As he says in the motion transcript at, I believe, page 59, I had a conversation with Mr. Denning. Then I went to secure the rifle. Denning at this point is on the porch. He's with at least 1, possibly 2 other officers. He's either handcuffed or being handcuffed. There's a glass door between Denning and this alleged rifle. And there's 5 or 6 feet of foyer on the other side of that glass door. Detective Seidel has Denning's cooperative. As I said, he's handcuffed. He's in custody. He's in the custody of 2 officers. He can't plausibly reach the rifle.
Everything's happening very quickly, right? One of the, I think it was Officer Flynn, said all of this was occurring simultaneously.
The exact time frame is not clear. Flynn does say it is fairly quick, but again, Seidel says, I had a conversation with Denning.
I took that to be referring to the initial back and when the defendant comes out and says, is this about the pizza delivery?
If Denning had said that as soon as the defendant had passed him, he reached in to get it, we'd have a different case. If he had said he pushed past Mr. Denning to seize this thing, we have a different case. But what we have is the defendant's on the porch with a door with 5-6 feet of space. By the Commonwealth's argument, and they have no indication anyone else is home, by the Commonwealth's argument, they can enter whenever they see a visible weapon. If it was in the living room, they could have gone in and ventured to the living room to go secure it because there might be somebody home. If it was visible in the second floor bedroom, they could enter, go up to check it out because there might be somebody home. That's a bridge too far, Your Honors.
Well, they need probable cause to enter the dwelling, correct?
They need probable cause and they need the exigency. And their probable cause is in part they're told that they're responding to the pizza driver was threatened with a firearm of some form. But their primary concern is that public safety. They also assert the storage problem. I have a problem with that because it allows the police to create the exigency if, again, they don't know at that point. If Denning had a permit, the firearm could have been lawfully stored in his control. He comes out to greet them. They've made it insecure. And that, again, that's a bad policy argument to say to gun owners, you have to keep the firearm with you. If you step away from it, you've committed a felony. The police want you to step away from these weapons so that everybody feels safer.
But you have a report that you have a report from someone who's called the police saying someone just threatened me with a gun. Why isn't that enough to establish probable cause?
Why is that not?
Why is that not enough to establish probable cause? And then they show up and they see something that looks like a rifle
But again, they're
in the
claiming
foyer.
exigency for the entry. They're not claiming they're securing evidence. They're not claiming the evidence is in danger. They're claiming exigency.
Right, but you also need probable cause.
You need both. And I'm saying they don't have the second half. Regardless of whether they have the first half, they don't have the second half.
Second half
They don't
meaning
have the
exigency. The second half meaning exigency?
They don't have the exigency portion, Your Honor.
So there's no exigency when a police officer sees what looks like an AK-47 after having received a report that your client just threatened a pizza delivery guy with it?
If I believe it resembles a AR-15, not an AK-47.
Okay.
Technical point, I suppose. But he can't plausibly reach it. If, for example, let's say he had stepped further, he's now on the lawn, he's 10, 12 feet from the door, do they still get to go in to seize it? Again, not knowing that anyone's home. How far can they go under the state's logic to seize this thing if the persons that are visible cannot plausibly reach this item? How much do we let police go into the home? Now, let me step to the next point in the process. Seidl's entered the home, and if this court believes that's reasonable, now the question is, does he get to remain? He enters the home, he picks up this object, he immediately, upon touching it, realizes this is plastic. This is an air rifle. He secures it. He doesn't, he's not asked the details of how he secures it, but there's a moment where he is securing this thing, where he's still in the entryway, and then the grandfather enters. I submit he has remained in the home unconstitutionally. He should have taken that across the threshold and then talked to Lloyd from the other side of the
What's
threshold.
the consequence of that?
Well, the consequence is by being in the foyer, that moves into the following question of, is the grandfather acquiescing to apparent authority? Because the police are already in his home. They're holding his property.
So you're saying that it somehow affects the voluntariness of his consent later?
I think the primary
The fact that they had the
harm is
conversation
voluntariness.
inside rather than outside, the fact they had the conversation inside rather than a few feet away on the porch affects the voluntariness of his consent?
I think it does. I think there's a significant psychological difference between having a uniformed officer standing inside your house holding your property. As the trial court says, Seidl tells Lloyd he wants to go see Lloyd's revolver. The conversation that occurs from there is in the context of the officers already in the home, as opposed to on the other side of the threshold. Thresholds are really important, both psychologically and legally. At that point, Lloyd can see there's armed officers outside with Mr. Denning. There's more armed officers in the yard that are with his granddaughter. This is a coercive situation.
Was this issue raised below
Which portion, Your Honor?
about him basically overstaying when he gets into the foyer, he should have left once he secured the rifle? Was that raised below?
Your Honor, I believe it's discussed with the motion judge, but I can't give you a transcript cite at this moment. There
Because
should be
one-
a transcript cite in the brief.
One could invite an officer inside, right?
One could, but he didn't.
Okay. Well, how do we know, so he secures the air rifle, and then Mr. Lloyd appears moments later, I think was the testimony. how do we know that the conversation, which I take was, a friendly conversation, did not suggest to the officer that he was essentially inviting him into conversation inside the house?
The officer never asserts he was invited. He never asserts
Well,
that
I'm
he was
asking
welcome.
whether
What
this
he's
was an
saying-
issue that was raised before the
Listen,
judge.
I believe it was in the discussions. The transcript cites to it would be in the brief. I don't have them in front of me.
Okay.
And again, this brings us into into what happens between Detective Seidel and Mr. Lloyd. And we have, from Seidel's perspective, this is a friendly conversation. From Lloyd's
Right,
perspective, it
so,
isn't.
So the police testify about Mr. Lloyd telling them about his model airplane collection and having a friendly conversation. From the Mr. Lloyd's perspective, it's more aggressive. But the judge, Judge Goodwin, saw these witnesses and credited the police version. So what do we do with that?
I think you have to pay attention to the timing. The friendly conversation about the airplanes and his service is with Flynn, and that occurs after they've already gone upstairs, they've been in the safe, and they've seized the revolver. That's a subsequent conversation. The conversation in the moment is Seidel comes in, he's holding the rifle, he says that he's there about the pizza guy. He asks whether there are any other weapons in the house. The grandfather says yes, and he says something to the effect of, he doesn't remember exactly what he said, but he says something to the effect of, let's go upstairs and see it. Bring me upstairs and show it to me. Let's go upstairs and see them. And that's at motion transcript at 81, 83, and 86. There's no consent to search. The judge describes this in Record Appendix 25 as Seidel tells him he wants to see the gun. He doesn't ask him, can I see the gun? He doesn't say, can we go upstairs? He doesn't offer a consent to search. He doesn't tell him he can say no. He says, let's go. And to which Denning's response is essentially, well, what the heck else am I supposed to do? I've got armed officers on my doorstep. What do you expect me to do? And I think we have an acquiescence to authority here. I think this is an unconstitutional search. This is not the way, Your Honor, this isn't the way I'd want my father treated if the police came to my house and wanted to search it. It's not the way I'd want my father-in-law treated if police came to my house and said, hey, are there any firearms in this house? We want to go see them. Or went to my father's house and said, hey, we want to see your firearms. This is, again, from the officer's perspective, it's friendly, but it's certainly firm, and it's certainly telling somebody we're going to do something, not asking somebody, can I go deeper into your home? Can I see your property? If there are no questions about the ammunition counts, I'll rest on the briefs for the remainder.
Okay, thank you, counsel.
May it please the court, ADA Carmel Motherway, representing the Commonwealth. Good morning.
Morning.
In this instance,
I'm going to need you to speak up a lot or pull the microphone closer.
in this instance, there are two Mr. Lloyds. There's the Mr. Lloyd that wanted to ingratiate himself with the police and actually was reverted back to that. And when he related that a lieutenant had come to the scene afterwards and said he was a good guy and he was very pleased about that and his relationship with the police. He was at times truculent in his testimony with before the motion judge, which speaks to he had a mind of his own. His will was not overborne. He was arguing with the motion judge and at various points. In this instance, where Officer Seidel could rely on the fact that this gentleman came up while he was seizing the rifle. He had just seized the rifle. Its meaning and import is apparent to the officer, but that doesn't diminish the fact that this type of weapon, a BB gun, can be a dangerous weapon. That's established in our case law. And it could also be used by the defendant should he get it out of the possession of the officer, or even if the officer had left it there, to cause considerable damage. So at that point, the officer did not know if others were in the house, so he had to seize it. But when Mr. Lloyd came, that still didn't assuage the officer's concern about the possibility of others in the house. The temperature of that house, or the temperament of that house, and the temperature with respect to their emotions was such, he did know that the response to a late pizza delivery was an assault by means of two different weapons. They had interviewed, as the court noted, this was a very quickly evolving situation. They had not, it didn't appear from the transcript that they had interviewed the driver. They interviewed him en route, like as they were at the scene, and learned that there was something that looked like a semi-automatic and a handgun involved.
That occurred, oh, I'm sorry, go ahead. That occurred later, right?
Yes, yes.
Okay, so to the extent the judge found that the responding officers were aware of two guns, that would be clearly erroneous, right?
No, I think that there were different things going on. I was parsing the testimony. There was the first officer who was speaking to him. There were two officers who testified, and they were interviewing the delivery driver. He was at the scene, but away from where the defendant was. And my impression from that was that this was ongoing. Siddell was not one of the ones who was securing the defendant, but his testimony left on its face stated that at a certain point he learned from the delivery driver the description of these weapons. And back to Mr. Lloyd, there was concern about further weapons, and the officer was acting perfectly properly for officer and other people's safety in inquiring whether or not there were further weapons in the house.
So when did the exigency, there's a continuum, but when would you say the exigency concluded? Because defendant may argue that the exigency concluded or was resolved when the officer recovered the BB gun, but you're saying it hadn't concluded yet.
I don't believe so. There was a possibility of other people in the house, other firearms in the house, and again, the type of situation they were encountering where somebody pulled firearms and pointed them at a delivery man because he was late and the pizza was cold does not, I don't think that the officer is required to think that that's an ordinary reaction, or that this household is, or that Mr. Denning himself is an exception to that type of response, is unique in that response. There may be others, and if there are other firearms and other individuals, then the officer wanted to know that. So I think that the exigency probably concluded with the retrieval of the two weapons that were described by the pizza delivery man, which would have been immediately the BB gun and secondarily the pistol that was used.
But the recovery of the firearm from the safe, you concede that that was supported by consent, correct?
Yes.
And if there were no consent, you would argue that that was still allowed through exigent circumstances?
To enter the home and go upstairs and do that? No, Your Honor.
Okay, very good. I just wanted to make sure
Yes,
on
no,
that
no,
point.
no. But
So how
I'm
do you
saying that-
respond to the argument that once he secured the BB gun, he should have stepped out of the house?
Well, there again, the testimony was that he was securing it and that Mr. Lloyd came out from downstairs to chat with him. I don't think that he was obligated to inform Mr. Lloyd that he could tell him to leave. If Mr. Lloyd was initiating a conversation with him, Mr. Lloyd is the one who told the officer that pointing a gun at, he didn't see a problem with pointing a firearm at somebody who had sworn at you. And so that meant that he was a precipient witness to, and he did tell him that he saw the whole thing. The officer did tell him that he saw the whole thing. And then he described what the individual, his son-in-law, had done. So the officer wasn't obliged at that point, he volunteered all those things, to say, oh, well, let's step outside, I don't want to remain in your home. I mean, Mr. Lloyd, I believe, was a combination, until he knew or apprehended, I think his demeanor at the scene was different than his demeanor as he describes it before the motion judge. And
At what point in time did he tell them that, because it was election night, he was concerned about the election, he had a loaded gun out on the table?
he told him that almost immediately. You know, they're in the foyer and he's talking about that. So that again is like this idea that this officer is now in a home with a BB gun, two officers outside with the gentleman who allegedly brandished both weapons against a pizza delivery man, with people who are of that mindset. And that would raise their, heighten their concern for their safety and others. I mean, the neighbors were out. There were neighbors down the street, across the street, who were out. And so I think that for the officer to have left at that point would not have been wise.
I have a question for you about the ammunition.
Yes.
I understand that you're conceding that under Brown, the 2018 case,
Yes.
the Commonwealth didn't prove that the defendant knew that the revolver was loaded with ammunition. And yet you're asking us to remand for retrial of the possession of ammunition under Guardado. Which ammunition would you be seeking to prove that the defendant possessed on the retrial?
That within the pistol.
So you can, even though you're conceding that the Commonwealth didn't prove at this trial under a 2018 case that the defendant knowingly possessed that ammunition inside the revolver,
Right.
or you can retry that?
No, Your Honor, if the court disagreed with our concession and we were going to retry it, then we would do that. But if the court does not agree with our concession, we would go back and try it, and it would be as to the pistol.
You're not saying that there was sufficient evidence that this defendant had constructive possession of any of the ammunition in the grandfather's bedroom?
Not at this point, no. I mean, there's even, not at this point, Your Honor. If the court has no further questions, the Commonwealth will...
There's just a
Yes, sir.
few more. You would concede, would you, as a judge found, that it would have been better practice for the Detective Seidel to present a written consent form to Mr. Lloyd?
That may have been better practice. This was a radio call. I don't know if they carry them in their cruisers. This was a radio call that came through, and there was a significant officer response to a pizza delivery man being threatened with a firearm. But, I mean, if that's part of their, that never was established at trial, whether they carry them in their cruisers or how one would do it.
Okay. Thank you, counsel. Thank you
Thank
both.
you.
The case is submitted. The next case is Commonwealth versus, I'm going to say Alisea, number 2023 P 1400. Did I pronounce that correctly, counsel?
Good morning. May it please the court. Travis Lynch for the Commonwealth. The defendant in this case didn't prove at the motion to suppress hearing that he was in custody for purposes of Miranda against Arizona. The judge erred in suppressing the defendant's statements as a result because of the failure to give the warnings until later on in this interview. The entire case is, of course, most of the case is open to de novo review, as the video was submitted to this court as well for its review. I think that, or I'd submit that there's like a collection of errors here. And I think a big problem with the judge's decision here was that she thought it was important that Lieutenant Elliott had enough information to establish probable cause to arrest, and also that Lieutenant Elliott testified that this interview was going to happen. And this is a problem for the motion to suppress decision because the judge attributed all of that, essentially, to the defendant's knowledge. The full extent of Lieutenant Elliott's knowledge about the facts of the case is not communicated to the defendant until pretty well into the interview. What is communicated to the defendant does not include the statements from the complaining witness and her father, the fact that Lieutenant Elliott saw visible injuries on the victim, and also the fact that Lieutenant Elliott saw a video. So to the extent that the judge attributed the full state of Lieutenant Elliott's knowledge to the defendant's knowledge is error, where Lieutenant Elliott didn't tell the defendant that he knew all of those things. And the other, I think this is similar to the Medina case where the judge in Medina attributed quite a bit of the police officer's subjective knowledge and subjective intent to the defendant's knowledge. It would be a different case if Lieutenant Elliott had told the defendant, we have a video, I saw injuries, that sort of thing. It would also be a different case if Lieutenant Elliott had told the defendant, this interview is happening whether you want it to or not. But on this record, Lieutenant Elliott doesn't tell the defendant that at all. So the judge, I would submit, commits error in attributing the officer's subjective intent, attributing that subjective intent to a finding of custody.
The judge, Lieutenant Elliott told Sal Sayah that he had responded to a 911 call, correct? Domestic assault.
That's correct.
And he said that twice the victim or the person he spoke with had named him.
Yes.
Named him.
She named him by name, yes. That's
and
what
he's talking to a police officer, right?
A police officer himself is talking to another police officer, yes.
Correct. And the police officer who's being interrogated or questioned, a reasonable police officer would think that a lieutenant who responded to a 911 call for domestic assault and said that the complainant had named the said officer twice, would that person think maybe they're a suspect?
My argument is that the judge's decision factored in a bunch of other things that Lieutenant Elliott indisputably did not say to the defendant. If it weighs in favor of custody, it doesn't weigh in favor as much as the judge thought that it did. And also in the video, there are other statements that Lieutenant Elliott makes to the defendant, such as, we have to get both sides of the story. So the judge, I believe, ignored that aspect of what Lieutenant Elliott said to the defendant.
Do you have cases about whether or not someone is in custody at their workplace, where their workplace is a police station?
I couldn't find any cases where that had specifically happened before. The closest thing was what was it called, Galudi? But that wasn't a police officer case. That was a person who was at his Galati. That was a person at his place of work, but there were a variety of other factors that weighed in favor of custody, such as the door was locked, there was an armed guard.
I mean, Galati's pretty close, right?
It's
a correction officer, I believe.
It's right. It's a correctional officer.
He was at work, voluntarily at work, but he was taken by superiors to a separate room to be
A
questioned.
different locked room in a
Right,
part of the
putting
jail.
aside the locked part, he's
That he doesn't-
taken
Yes.
by his superiors to a separate room, and we found that he was not there voluntarily, just because he happened to be in his workplace voluntarily. So how is that distinguishable?
It's distinguishable because, well, in this case, everyone's disarmed. Galati is a locked room. This is a room with an open door. It's not an interrogation room. There was testimony that all of the officers in this police department are familiar with this room and have access to it. This is not, you're not being held incommunicado here. This is not, so.
Right, but it can't be that just because you're at work voluntarily, it necessarily means you're being questioned voluntarily, right? I mean, which is what you seem to be arguing. Because he was there working, that weighs in favor of voluntariness. And I'm not seeing that because he's taken from his regular post to a separate room.
Yes, but it's not, again, it's not to the extent of Galati because, again, it's not a locked room. And again, there's no testimony about what the defendant actually thought during this whole interaction. There's no testimony from the defendant saying, I felt like I wasn't free to leave.
Is there any evidence if under Carney v. Springfield, the police had made it clear to the defendant that there'd be repercussions if he refused to talk?
I had thought about that Carney issue, but there is, as far as I know, there's no evidence about that. There's nothing in the record regarding a Carney issue.
Is it implicit that there'd be adverse consequences to an officer who tells a lieutenant, I'm not interested in speaking with you right now? Lieutenant and a sergeant approach him, say, we need to talk to you. I mean, that happened, correct?
Yes.
What's the officer to say? But yes. Do we need testimony that there would have been an adverse consequence if he said no?
I would say yes. I would say he would need a testimony because the defendant has the burden to establish he's in custody. Because there's no testimony about, I mean, yes, I would say on this record, it's not, the defendant doesn't establish his burden. If maybe had there been testimony on the point, maybe it's a different outcome. But on this record, it's not established. What you just said is not established on this record.
How would a police department operate if subordinates were free to disregard questions by their supervisor or commands that we need to speak with you? It was, we need to speak with you, correct? That's what those are his words, correct?
I believe so.
The supervising lieutenant on the shift says, we need to speak with you. And you offer today, you believe we would need testimony to infer that if that officer said, no, I'm not interested, I decline, there'd be an adverse consequence.
I would say yes. Because the defendant has the burden to prove he's in custody. The Commonwealth doesn't have to prove anything as to this point. There's a few other, let's see. Again, you can watch the video for yourselves. I don't think there's a real disagreement that the tone of this interview itself weighs in favor of custody. But again, we would just say, on this specific record, the defendant didn't carry his burden. I mean, the Commonwealth put on the witness. The Commonwealth put in all the evidence in this hearing.
On that third factor, the nature of the interview,
Sure.
don't the cases suggest we look just beyond the tone and we look to the direction of the questioning, the content of the questions?
Yes.
Okay, so even if he wasn't overly aggressive in tone, wouldn't you say that it wasn't just conversational, the lieutenant was controlling the direction of the interview?
He was trying to. I mean, he was trying to get the defendant back on track to talk about that day, yes.
So doesn't that weigh in favor of the defendant?
It may.
Okay.
Unless there's any additional questions, we would just say that.
Yeah, I did want to ask you a few more
Sure.
questions about probable cause. Lieutenant Elliott responds to a scene. He speaks with a named victim, identified, visible injuries, correct?
Yes,
And she reports that she was assaulted by the defendant in this case.
correct.
He speaks with her father, who's a precipient witness, correct?
Also correct.
And he corroborates to a certain extent what she says, correct? That there was an assault.
Right, through the video.
And Lieutenant Elliott testifies that he doesn't believe that's probable cause.
I thought that was interesting as well.
It's interesting. The judge found it was probable cause.
Right, but that's irrelevant because the fact that he has probable cause isn't communicated to the defendant.
I understand that, but the defendant, knowing again what he knew, that they respond, well, actually, withdraw that. I've asked you along those lines. Well, no, let me continue then. Because a defendant who's a police officer who understands that a supervisor was called out to a domestic violence incident and took a report from a complainant who named that officer, again, he said it twice, she named you, isn't it reasonable to infer that that police officer would think there's probable cause for his arrest based on that information? Not John Doe, a citizen, but a police officer.
That the police officer is inferring based solely upon the officer saying, I responded to a domestic violence call and the victim named you. That's, I mean, they didn't say, if that's all that he said. No, I don't think,
So the lieutenant
You're
doesn't
saying-
respond to every 911 call with a domestic, correct?
I don't know as a factual matter.
Well, I believe he testified he was called there because the supervisor, the responding officer called him because of the situation.
Right.
So this is not a usual response by a lieutenant to go to a 911 call for a domestic violence incident.
That seems to be the case, but I don't think that the defendant necessarily knows that. I don't think the defendant necessarily knows that it's an extraordinary situation.
And what do you base that on?
The fact that there's no evidence in the record?
That he's a police officer that works in that police department and that he doesn't know the procedures of how they operate?
I'm not sure if the defendant knows that it's, I don't think the evidence shows that he knows that the lieutenant would only be responding because of something like this. Unless there's any additional questions, I'd ask that you reverse the order.
Okay, thank you, counsel.
Thank you.
Good morning. May it please the court. Daniel Kelly on behalf of Jeffrey Alisea. With me also on my right-hand side is Attorney Kyle D'Souza. Thank you. The issue before you is a fairly narrow one. The issue before you is whether to determine whether or not Mr. Alisea was in custody at the time of the interrogation. The cases have determined to look at what were the circumstances surrounding the interrogation and what would a reasonable person have felt if a reasonable person would have felt he was at liberty to terminate the interrogation. The SJC lays out factors in Groom, which the court has considered and the court has layered into her opinion. The first would be the place of the interrogation. As the court has already pointed out during the Commonwealth's portion, this case closely mirrors Galati, the CEO at Worcester County House of Correction. Mr. Alisea was at his post inside the Springfield Police Department. He was at the front desk. This wasn't a casual conversation in the hallway.
If they'd had the same conversation at the front desk, would it have been custody?
Well, in a contextual vacuum, perhaps not, but I think I'd have to see what the record would be regarding that. But I think that would certainly be a better factual scenario for the Commonwealth, yes. I think that leading him away from his mandated post, directed by an officer who he owes, as the case law refers to, an obedience, duty of obedience, as the case law discusses, leading him away from that post, a supervisor directing him to do that, directing him through these doors, directing him to this area on the side of the booking dock to what they call the OUI room, and putting between him and the door a desk and two different superiors, I think mirrors Galati. Yes, the door, the Commonwealth makes a big fact out of the door wasn't locked, but I would suggest that's a reasonable difference or distinction without a difference. For all effects and purposes, he was in custody. It would have been much easier to get through a locked door, perhaps, to get through two supervisors in a desk in a small confined room, a nearly similar shape as Galate. So I think the place of interrogation favors the Commonwealth. Second, which we've talked a lot about, whether the officers told the defendant he was a suspect. They did in so many words. They said, "Hi, we want to talk to you about what happened today. Your girlfriend called. She said you assaulted her." He was told from the outset he was a suspect. This is not a fact-finding mission. This was accusatory. In fact, when Mr. Alicea tries to begin the conversation with, well, let me tell you what happened before. No. They bring him right back. I don't want to talk about that, Lieutenant Elliott tells him. I want to talk about what happened today. He tells him, I've been out there. I've seen the video. I talked to her father. I've talked to her. She called 911. She said you did this. So I think the officers definitely conveyed to him, whether he's a police officer or not, that he was told he was a suspect. The nature of the interrogation. Now, the court does note that the nature was not aggressive, and that is a factor. However, that's not the determining cause here. The contours of the interrogation are what really matter here. For example, you can be polite and direct. You can be non-aggressive and accusatory, and that's what happened here. Again, every single time Mr. Alicea tried to talk about and give some contextual background as to what happened prior to, Lieutenant Elliott immediately brings him back here. Just because he was not impolite does not weigh against him. Certainly, he was not aggressive, but he was direct, and you'll be able to see that for yourself on the body-worn camera. Next, at the last factor is whether or not at the end of the statements the defendant was free to leave and whether there was evidence of arrest at the end. We know that there was evidence at the end. A lot has been made by the Commonwealth that the court made an error of law. It suggests that she did not. Judge Cafaro did not. They tell you that, well, she took into account the unexpressed view of the defendant that he couldn't leave, right? The unexpressed view that this interview was going to happen no matter what. But the fact of the matter is, and that she uses an outdated analysis using Bryant and not Groom, but the fact of the matter is that's belied by her written decision. In her written decision, she specifically talks about the Groom factor. Specifically, in her written decision, she cites an opinion by this court that says the unexpressed view of the police officer is not dispositive, which is exactly what happened in Medina. In Medina, the case with the skulls down in Hartford, that case, the court said and flipped it because it was the sole reason entirely on the subjective, uncommunicated views of the officers. In this particular case, the judge cites an appeals court decision that states that is improper. So to suggest that she made a improper ruling of law, I think is belied by her opinion, which correctly states the status of the law. I think each and every factor here, and again, I go back to Galati and some of the other cases cited, but this is someone who owes a duty of obedience to both Sergeant Sleeper and Lieutenant Elliott, who's given a direct order. This is not a passing conversation in a hallway.
So what's the lieutenant supposed to do if he has a police officer on duty with a firearm at the front desk, and he receives a report that someone has reported domestic violence? Is he supposed to not question him? Have a nice day, go back to your post?
No, he's supposed to do just what he did, with one exception, Your Honor. He should have read him his Miranda warnings.
Earlier?
Yes, at the outset of the interview. Clearly, the interview was going to happen using his own words, although unexpressed. The proper thing to do in response to your question would have been to read Mr. Alicea his Miranda rights.
You familiar with the Garrity warnings?
What's that, Your Honor?
Garrity warnings, Garrity v., I believe, New Jersey. It's a federal matter in which the court held, I think there were police officers who were given a choice either to answer questions that may be incriminating or they lose their job. And the court held that was improper. There wasn't anything explicit like this here, but did you find any cases where by a supervisor requesting or telling somebody they need to speak with him, there's any implied coercion?
Well, I think Galati says that. The House of Correction, in that case, it says the defendant was, he was questioned by a superior.
Duty of obedience, correct?
What's that, Your Honor?
They mentioned the duty of obedience in that case.
Yes.
Right.
That's, I think, maybe not mirror the exact language of Garrity, but I think that's exactly what the court was referring to. That what choice did he have? He owed a duty of obedience to that, in that case, to his supervisor, who was there with a note taker in that room, which he was led to, much like Mr. Elliott led Alicea in this case. And clearly, Lieutenant Elliott testified the sole reason of his purpose is because he was, in fact, the superior officer. That was the whole reason he was involved. So I think, again, this mirrors the Galati language that he did owe a duty of obedience by training in organizational command to Mr. Elliott, Lieutenant Elliott.
Did you find any police cases, any cases where there's a discussion about whether someone's in custody at a police station?
Just Galati.
What confuses me a little is that most of the police defending cases are situations where the defendant wants to get in at trial the statements that he made to the superior officer, like Shaner, because they're exculpatory. So I sort of feel like we're flipped, and that if the Commonwealth prevails on this, you're going to be trying to get these statements in, or more of them. So.
Well, if the Commonwealth prevails, they'll come in, so I won't have to worry about that. They'll come in on the case in chief, and I'll be able to use my cross-examination, hopefully, to spin them in my direction, but I don't think I'll have to make that decision. I don't think I'll have to make. Certainly, if they win, they'll use it. But yes, no, the only one, as Mr. Lynch said, the only one I could find was the one he found, which is the correctional officer, which oddly mirrors the facts here pretty closely.
What about cases where somebody is in jail and they're questioned about a different crime? And the question then becomes, was their freedom more curtailed than ordinarily?
I didn't cite any of those, but I did read them in preparation for writing this and discussing them. There are cases that say that people there could willingly, give waivers, could willingly keep talking because they were talking about other crimes other than what they were for, and it talks about, again, the fact specifics of the interview here, what they were in for, and what they were being questioned with this follow-up. So I think it's a really different factional scenario than a police officer who is told to sit at the front desk, that's his appointed duty for the day, and then has a lieutenant tell him, come on in the back room, we're going to talk about what happened today, and then start buzzing questions at him, politely and not aggressive, but directly about what happened. I was told, we got a call from 911, your girlfriend says you committed a domestic assault on her, what happened? So I think that's different than perhaps the jailhouse type interview for other types of crimes.
What if the lieutenant really thinks there might be some good explanation for this? The girlfriend needed to be sectioned, or the girlfriend had some sort of a problem, or the girlfriend's not credible. Do we really want to have the lieutenant have to Mirandize him right away?
Well, let's assume for a second that's accurate. I mean, in this case, I think the facts would suggest completely otherwise. He went and interviewed her, he watched the video, he had a third-party witness. So I think the evidence in this case would suggest otherwise. But assuming that arguendo for a second, that in this case a factual scenario arose where the officer, Lieutenant Elliott, thought, maybe maybe there's no probable cause here. I don't know what happened here. So the questions in that case would be more fact-finding than accusatory, like unfortunately in this case for the Commonwealth, I think they're more accusatory. But I do think in cases where you have a superior discussing criminal matters outside of work, obviously, criminal matters directly to the person they're questioning, I think the better practice would be to issue Miranda warnings. How can it reasonably be said that Mr. Alisea could have rebuffed two different supervisors and said, no, I'm going to stay here? If they ordered him to go out in the field or to investigate another crime, he would have to follow it. So what would make him think he could rebuff their pointed demands to go into this room and answer questioning? So I think the better practice, to answer your question, would be in all matters regarding where there's even in the realm of possibility that there's an allegation that the person involved could be criminal conduct, particularly given the contours of where this place took place and how it kind of came together, to my original answer would be to read them their Miranda rights.
Does it matter that they picked the OUI room because of its privacy?
No, I don't think so. I don't think it helps the Commonwealth, certainly. I think it matters to the defendant because he had to be escorted there, told where to go. He had to obey those orders there. And they had just like in Galati, they had a small room where if you watch the videotape, you'll see Sergeant Sleeper standing there in front of the door. He's in that room. He's not leaving. I think a reasonable person would not believe they could terminate the interview, the interrogation, which is what the standard in this case is.
And I asked the prosecution this. Is there any evidence in the record that the lieutenant or the sergeant or anyone told your client this interview is going to happen because if it doesn't, you'll be subject to disciplinary proceedings under Carney v. Springfield?
No, not in so many words. No, they never use that phrase. If you don't answer this question, you'll be subject to disciplinary actions. But what they said is, we've got to get to the bottom of this. words to that effect. I need to know what happened. This is your chance. You have the floor, so to speak. Tell us what happened. But they don't use the threat of disciplinary action, but per se. But I mean, it's inherent. He's the lieutenant. Again, that's what Gladdy says. They have a duty of obedience. And I think the case law says that. It's not just us kind of gleaming that and piecing it together. It's a direct statement from the case law.
Okay, thank you, counsel. The case
Thank
is
you.
submitted. Okay, we'll hear the next case before we take our mid-morning break. So Norfolk and Dedden Group versus GP Contracting, Inc. and others, number 2023 P1199.
Good morning. May it please the court. My name is Frank Fragamenti. I represent the appellant, Norfolk and Dedham Insurance Company. This is a de novo hearing in front of this panel as a result of what we believe to be error in the lower court for a summary judgment that was denied originally and reconsidered and then allowed. And on the papers, this court can see the entire record. You can see all the exhibits. You can see all of the memos that were submitted.
Could I just ask you a preliminary question? On page 17 of your brief.
I'm sorry, Your Honor.
On page 17 of your brief,
Yes.
there's a section that's titled Statement of Material Facts of Defendant and Plaintiff's Responses. Is this a verbatim, the 9A statement that was filed in the Superior Court?
On which page, Your Honor? I'm
Page
sorry.
17 of your brief.
Okay.
I did not see the statement, the 9A statement in the appendix. And I'm asking whether this is a verbatim copy of what was submitted below.
I'm mixing up, Your Honor, the RA numbers. I'm sorry.
In your brief.
Yes, Your Honor. I'm sorry. I have it here. In which statement of facts, Your Honor?
In your brief, on page 17, there is a heading called Statement of Material
Yes.
Facts.
Yes, Your Honor.
Is this the 9A statement that was filed below, but you're reproducing it within your brief?
Yes, Your Honor.
Okay.
This is what was filed in the lower court. There are so many disputed facts in this case, and I don't understand when you read the memo and you see the exhibits, I don't understand how the judge in the lower court could have said there were not material facts, there were
How
not
are you
genuine
going to
issues of
prove at
fact.
trial that the town installed the compression fitting that failed?
The town did. There are exhibits that are attached to the brief in the lower court and in your brief that indicates that they did install it in 2005. They went back.
Based on what? Who said that?
Their own records. We have the records that we subpoenaed from the town. Their own records indicate that they installed the meter, which they own. They installed the sleeving, which they claim in records they own. And our expert, Mr. Friedman, indicates that it is normal standard procedure for the town to come in and install a meter and connect it to the two fittings that would be on either side of it. Also, they would have to put some shutoffs on those sleeves, and they did not do that. So our expert is pretty clear as to what he sees as the defect, and it fits very nicely in Chapter 258. There is no 10J immunity. There is no 10B immunity.
Is there any evidence, a deposition or answers to interrogatories from, I think it's Mr. Ladd, the builder of the house, or
Yes.
whatever plumber he used?
The records from the town indicate that there's exhibits attached, Your Honor, that indicate that there was no private plumber that did the work. It was the town that did the work.
Except Mr. O'Brien testified, looking at that was a permit, and that showed that.
That's an issue of fact and dispute, Your Honor. There are so many things that Mr. O'Brien did say that are countered, in fact, by their own employee, Mr. Gomes. So there is a second issue in this case, and that is, was there a delay in shutting off the water as it was pouring and pouring and pouring out? The delay is highlighted by Mr. Gomes's affidavit and Mr. Gomes's deposition. Mr. Gomes's deposition was taken, and he says that he was called at a certain point in time at 9 o'clock, and by that time, all the water is pouring out, started around 6 o'clock. He arrives at the scene, cannot find what's called the tie cards, which are required. The tie cards are required to indicate where the shutoff is in front of the house.
So were you saying, we're very familiar with the facts. Are you saying that the delay is because Mr. Lopes was not notified until 9 a.m., or are you saying that 90 minutes is an inordinate delay?
All of that, Your Honor, all of that. What concerns, what should concern the court is that when he was notified and he was within the 30-minute time frame that you're supposed to be, you live within 30 minutes of where you're supposed to be going, shutting water off, if there is an instance like this. He was within that time frame. He gets to the location. There are no tie cards. There's nothing that would indicate where the shutoff is. He looks inside the house, no shutoff. There's supposed to be a shutoff. And so when he gets to the main, which is up the street, he opens up the main area and sees it completely clogged with debris, with leaves, and with actual pieces of the grate that's owned by the town of Falmouth that just sort of settled in there. There are exhibits that show what the requirements would be for the town to inspect and to make sure that those things are clear.
To inspect the main?
Yes, and to inspect inside the house as well. And so
They're supposed to go in the house twice a year to inspect people's
exactly,
plumbing?
Your Honor. Yes, they are. They're in
Everyone in
their
town?
own. I'm sorry, Your Honor.
They're supposed to inspect every homeowner in town's plumbing twice a year?
It's what it says in their own ordinance and in their own codes. It indicates
But that's about a backflow device that prevents contaminated water from infiltrating potable water. Was this compression fitting a backflow device?
No, the compression fitting was inside the house, and the compression fitting, what we have been always saying is that the compression fitting, when you see the schematics that I've attached to the brief, the schematics show that part of both the meter and the two connections to it are owned by or provided by the city. They're provided by the city. And in this case, when you piece that together with the permits and with the records of when these things were done, you'll see that they were done by the town of Falmouth, no private.
Where does it say on the permit that the town installed?
The town installed it, yes, Your Honor. It says that in all of the exhibits that I've attached.
Where does it say that the town installed the compression fitting?
Yes, Your Honor, it does say that in, I can find it for
Your
you.
expert's affidavit?
I'm sorry?
Are you relying on your expert's affidavit?
Yes, the expert affidavit would also say that, but we went one step further and got the records from the town, and the records from the town are that they actually installed the meter, they own the meter, and they have, in order to put the meter in, you have to connect it with the two fittings, and so they had to have done it because no private plumber ever pulled a permit to do it. So they were there, they put it in, they affirmatively caused this sleeve to fail, and in the process of responding to the event, they did not do so according to their own requirements,
How are you going to prove causation with respect to any delay in response?
Causation is described in our expert's affidavit, which indicates it's more probable than not that the sleeve failed. And the sleeve over time...
I'm talking about the purported delay in responding.
Yes, there are cases at the end of my brief, Your Honor, that talk about that very issue. The Robinson case, Robinson-Cole case.
I'm talking as a factual matter, right?
It is a factual matter. It is definitely a factual matter.
I'm asking a factual question. So it's undisputed that when the fitting failed, that the insured went downstairs and opened the door, let the water out, and this occurred basically immediately, and after that point, the water level stayed the same. So how are you going to prove that any purported delay in response caused any damages?
That is another issue of fact that has to be developed through our,
What's an issue of fact?
the issue of fact of whether or not the water level.
It's undisputed. It's in the statement.
If that fact is undisputed, then the delay of getting to the location from 5 o'clock when it first started or 5:30 when it started to when it finally shuts down, the water is still flowing. Water is flowing, and it's not flowing. Even if it's flowing outside, it's raising and flowing, it's raising and flowing, it's raising and flowing. So if we were to say that all of that water is only as a result of the first 15 minutes, I don't think that's correct, Your Honor. I think it's as water just keeps pushing and pushing and pushing, it's going to rise, it's going to fall, it's going to rise, it's going to fall. And so when the cases that indicate that there's a delay in the getting to the location and actually shutting it off, it took 90 minutes to shut it off. That is not acceptable. That's not acceptable to the town, even though Mr. O'Brien says it is. It is not.
Excuse me, counsel. It's undisputed that the water level, once the door was open, dropped to 2 inches, and it never rose past 2 inches after that. So I'm still not seeing how the delay would contribute to any damages.
That is an issue of fact, Your Honor.
It's undisputed. It's in the statement.
Well, if that's true, Your Honor, then what happens here is, again, the water rises, the water falls. It's not necessarily that it never went below.
The height of the water never increased after the sliding door was opened. Response, agreed.
So if you have a delay of 90 minutes, you still have water flowing, and the water flowing is going to still damage property. Whether it's $5 damage or $10 of damage, there is an issue of fact that's related to the delay. And so we're not here arguing that perhaps the entire $103,000 damage is due to a delay. We're arguing that some of it is. And initially, in order to fit into Chapter 258 and to fit into the case of Maglia-Cohn, which was submitted, which then...
Cleveland v. Newton?
I'm sorry?
Are you familiar with Cleveland v. Newton?
I am, Your Honor, just a wee bit.
Okay. Well, I have a question for you about the affidavit of the former employee.
Yes,
that
Mr.
he
Gomes.
was not notified until 9 a.m.
Right.
And I understand in your brief you say that that's a dispute of fact. What do we do with the fact that at Mr. O'Brien's deposition on cross-examination, you said, does the fire department report refresh your memory that the water was finally shut off around 6:30 a.m.? So is there a genuine dispute of material fact?
Absolutely, because
that he was,
absolutely.
It was shut off before the water guy woke up?
That's the issue of fact that has to be developed. Mr. Gomes is the key witness here, Your Honor. He's the one who responded. So his affidavit says what it says, and his deposition
That he wrote
testimony.
5 years later. Almost 5 years later, and my best memory is it was 9 a.m.
And the town's insurer wrote us a letter saying the same thing. And so when we deposed Mr. Gomes, he's saying, I remember this is what happened. I remember this is what happened. I remember this is what happened. And so his testimony will definitely conflict with Mr. O'Brien's testimony, who is testifying about things that he does not know. He's also saying that there's, that the service of the town ends at the curb. There's no case law that they produce about that. There are no statutes that are produced about that by the town. So that is just conjecture. That's just standard procedure that Mr. O'Brien may use or may say in his process of defending this case. But it is not anywhere in any statute, any ordinance, anything that indicates that the machinery that's supplied by the town ends at the curb cut.
Where do you, from the record before us, where do you get the information that the equipment supplied by the town includes not just the water meter.
Yes.
But it extends to the pipes
Yes.
and the compression fitting on either side. Does it extend to the toilets and the sinks? Where
No,
does
it stops, I've attached all of those exhibits, Your Honor, which indicate that it stops at the two fittings. The two fittings come from the town.
Who said that?
The town says that. They're in the exhibits that I've given you, Your Honor. They indicate that, and I've circled them actually, the meter valve, which is an L-shaped form, and the brass valve that's connected, it says specifically, furnished by water department, installed by contractor. The only one who installed this was the town, because all of the records indicate that the town installed it. There's nothing that indicates a private contractor installed it. Now, if all of what I'm saying is believed, we can prove an affirmative act by the town, and we can prove a delay. Whether or not the delay is worth $5 or $1,000 or $100,000, that's an issue of fact.
So when that spec at page 102 of the record appendix says furnished by water department, installed by contractor.
Yes. However, in this case, we know for a fact that it was installed by the town.
How do we know that?
It's in the records. It says the sleeve is installed by the town. It was removed and reinstalled by the town in 2005 and
Which
2006.
record? Which exhibit says that? Exhibit
That exhibit,
8?
Your Honor, would be in, let's see here. It's towards the end, Your Honor, and it has 5 or 6 pages of schematics, and then it has the notations of the city as to what they actually did at the home.
Removed 1-inch meter that froze and cracked, installed new 1-inch meter, and wired the RR6 to it. Are you saying that shows that they installed the compression fitting?
Yes, the documents, Your Honor, that are, I think it's RA, starting in RA 160, it talks about located gate, flush the installed meter, remove spacer, shut off that meter. That's in 05. So they were there in 05 at the spacer.
So how do we know that the compression fitting that was installed in 05 was defective 13 years later?
It was installed in May 16th of 05. Removed meter that froze and cracked, installed new meter, wired, I can't read the rest of it, but so their own records, the town of Falmouth's own records, indicate that they installed the meter, this particular meter that failed.
But my two questions for you are, does it say that they installed the compression fitting? And where does it say that the compression fitting was defective when installed, that caused the leak 13 years later?
My expert indicates that when you install the meter, you have to also install the fitting. You cannot just put the meter in and walk away, because then you'd have nothing on either side. So you have to put the meter in that's owned by the city, and you connect it with the connector that's coming from the basement area, and then you connect it, and then you connect it to another one. So you are actually installing the whole fixture. You're installing the whole thing.
But those are facts
Yes.
that are underlying your expert's opinion.
Yes.
How are you going to get those facts in at
Through
trial?
the actual town records, which indicate that they had to installed the meter, no doubt about it. So when you install the meter, you have to install the compression fitting. You have to. You cannot just put the meter in. You have to connect it, and the connection is what failed. That's what failed in this case, that connection. So it's not possible to have water service without installing the meter and the compression fitting.
Do you have any discovery from Mr. Ladd about who did the plumbing for the house back in 2004 and 05?
Before Mr. Dowling owned it, what we were able to find are what I produced for you, the entire file from the town of Falmouth with all of the records, and it shows the history.
But what about the builder?
The building itself?
The builder,
The builder-
contractor, the person who built the house.
What happened after the builder who built the house, then all of this occurred, and then Mr. Dowling purchased the property. So Mr. Dowling purchased the property from someone who had lived there prior to the incident. So if you look at all of the town's own records,
But I'm
you will
asking
see.
you about the builder.
Yes.
Who built the house.
Yes.
If he has records about who installed the plumbing
What-
in the house
it's-
that he built.
I think it's irrelevant, Your Honor, because we have all the records from the town saying that they installed it.
Okay, you're
And they
well
installed it
over
on-
time, but I had one more question. What is it that we're looking at RA 102, this schematic, which is dated August 2002? What is this diagram?
Well, the diagram at, which one, Your Honor? I'm sorry.
At Record Appendix 102 and 103, there are these two diagrams with circles on them, and the date is August 2002. So what is this document?
You're saying 102, Your Honor?
102 and 103.
That is a Town of Falmouth document that indicates that they furnish these items. They furnish, the Water Department furnishes the,
Not specific to this property, right? Because it's dated 2002.
but that would apply in this case, Your Honor.
Is this something that relates to this property, or is it something more general about the town's practices?
No, this is something that the town utilities division produces, and they say, as of 2002 forward.
Okay,
This incident occurred at that time. So,
okay, thank you.
thank you.
Morning, Your Honors. Jason Crowdy on behalf of the town. I'm happy to answer questions first, but I could just give you a brief overview of our position, if that makes sense. In our view, there are two counts pled against the town. One is a breach of contract claim, one is a negligence claim. In our view, the lower court correctly decided both of those counts on summary judgment in the town's favor. One thing I wanted to raise very briefly, based upon Your Honor's questions, there were two other entities that were sued in this case before the town was brought in. Both of those entities had to do with the building of the home. The town does not build the home. The town does not install the plumbing. The town does not own the plumbing in the home. The ownership of the town's property ends at what's called the curb box, which is usually located at the sidewalk where public property ends and private property starts. The only piece of equipment inside of the structure, in any structure, in any of our homes, would be the water meter.
Do you agree that if the town installed the fitting, that would be the original cause and 10J wouldn't apply? If the town installed the fitting?
The fitting or the water meter?
Whatever it was that failed, the fitting.
So first I would say that the town did not install the fitting.
If, assuming they installed the fitting, do you agree that would be the original cause and 10J immunity would not apply?
I don't, for a couple of reasons. One, the house was built in 2005 or 2006. This event happens in 2018, so it would be sort of akin to a products argument where we'd have a statute of repose issue. I mean, all types of metal couplings, things of that nature.
Well, the statute of repose isn't in front of us, so just in terms of 10J, would that be the original cause, assuming they installed the fitting?
I would say that the failure of the coupling is the cause of the water intrusion.
So, can you explain to me how we can decide on this record that the town did not install the fitting, how that's an undisputed fact?
Sure. So, again, there's two counts before the court. One is a breach of contract claim, and one is a negligence claim. And I think both of those relate to your question, so I'll take them very quickly in turn. First of all, in the factual record, there's a acknowledgement by the homeowner that there was no contract between the homeowner and the town with respect to this fitting or with respect to any other work. The home was purchased in 2008. The fitting fails in 2018. Plaintiff's counsel tried to cite the Maglia-Kane case, Maglia-Kane versus Gardner, in order to establish that the town's sale of water was some type of proprietary function which would enable a contract to be in place. I happen to know the Maglia-Kane versus Gardner case very well because it's my case. I've been litigating it for the last few years, and I'm continuing to litigate it. So in Maglia-Kane, the court, the SJC, once and for all, decided the issue that a municipality's involvement in an activity such as the sale of water to the public does not take it outside of the Massachusetts Tort Claims Act, and here it would not provide any type of basis for a breach of contract claim.
But here, the issue isn't the sale of water with the low alkalinity, and like in Maglia-Kane. The issue, as I understand it, is the provision of this compression fitting that turned out to be allegedly defective 13 years later. Where in the record, as Judge Shin asked, where in the record does it say or that it's not a disputed fact as to whether or not the town installed the compression fitting?
So on page 17 of the plaintiff's brief, the 9A statement of facts, as was before the Superior Court on the summary judgment record, and it's relatively brief. The water department supervisor, Mr. O'Brien, I think sort of lays out what the town did or didn't do. In paragraph 6, he notes that the town did not install the plumbing equipment, the compression fitting that failed, nor does the town own it. To the contrary, it is the property of the homeowner. And that's Mr. O'Brien's testimony. The only dispute, it simply just says disputed, see town records. And in our view, those records are not pertinent to or relevant to this exact situation at issue. The other thing I think which is very important is the plaintiff's own retained expert, which is cited in paragraph 5. It says the compression fitting and the water meter were likely installed by the East Falmouth Water Department. It doesn't say that they were installed. He just says lightly.
So why isn't that a disputed fact for trial?
Because the town's water department supervisor testified affirmatively that it was not.
And that's disputed, and there's a statement from the expert saying that's established procedure that when a municipality installs a meter, they also install all the fittings that are attached to it. So, I mean, I want to give you the chance to explain why that doesn't create a dispute of fact, because it seems to me this is disputed.
So in our position, there's nothing in the summary judgment record that shows that the compression fitting that failed was installed by the town. The only thing that plaintiff can report to, can point to, is an expert report that says likely. That's not enough to.
So they can't put an engineer on the stand to testify that when you install the meter, you have to install all the fittings, attach the meter. You're saying that that's not enough to prove that the town installed it?
So my expectation would be that to put an expert on the stand to opine as to his opinion on causation, he'd have to have a good faith basis to believe, based upon a number of different things. He'd have to review the record or testimony from someone that says the town was the entity or the person who installed the compression fitting. Here we have undisputed testimony in the record from Mr. O'Brien that says we did not do that, and there's nothing cited in the plaintiff's expert report that he would be able to base the opposite of that on.
Well, what about the fact Mr. O'Brien was asked about the fact that Mr. Friedman's affidavit said there was no permit. It appears there was no permit, and therefore the town must have installed it. Mr. O'Brien testified at his deposition, yeah, there was a permit. It's at RA 165. It's this document titled Water Sewer Service Application. And then he was questioned about this handwritten notation, 102904, will send plumber so meter can be installed. How do we know whether that means that the town will send the plumber so the meter will be installed, or the contractor will send the plumber so the meter can be installed?
Right, so I've represented numerous cities and towns around the state and had this issue come up many times. It varies from water department to water department in terms of how this is handled, and I'm not going to stand before you and say anything to the contrary. In a lot of situations, and here we just don't know because this was done so much further back in town, a lot of times the plumber will be at the home when the water meter is put in place. Here, there's no record of who installed the plumbing. The plumber wasn't deposed in plaintiff's case. The only thing we know is that we supplied the water meter and we own the water meter. To have a city or town be responsible for a failure of plumbing inside of private property that it doesn't own or can't.
I'm not disagreeing with you. I'm saying, where do we find support in the record for the idea that it's undisputed that the town did not install the compression fitting?
So the only evidence of anyone who testified, who offered testimony, was Mr. O'Brien, who's the water department supervisor, and I think that is the spot in the record. Plaintiff, having brought the case and having the burden of proof, didn't offer really anything to the contrary, and I think the lower court, properly decided the motion for summary judgment in the town's favor.
How do you interpret Record Appendix 102 and 103, the Town of Falmouth Utilities Division documents? Does that not appear to show that they furnish the fitting that failed?
No, I think we don't have a way of knowing whether it's sort of the policies and procedures of the towns generally, as opposed to this particular piece of property.
We can't infer they followed their procedures in 2005.
I think it's really the real world reality of it is I think it's very case dependent upon what the plumber did. I mean, this is a new home being built, right? In 2004, 2005, the water meter would be, so the way that it sort of works chronologically is the house is built, the plumbing's installed, the water is not turned on, the water meter is the last thing that goes on. So what one plumber did versus another plumber did building a new construction home, we really don't have a way of knowing one way or the other.
But these documents that Judge Smith was just referring to, Town of Falmouth, Department of Public Works, Utilities Division, standard plans and specifications for the construction of and installation of water distribution and wastewater collection systems. Are those specs about what's in the sewers that's owned by the town, or are they about how to install valves and things in the house?
So the same department runs the water and the wastewater and sewage, so a lot of the documents that I think sort of blend together and are referring to different things. I don't necessarily think that that's talking about compression fittings and water meters with inside of a home or with this home in particular.
Is there any distinction if the fitting were installed improperly or the actual fitting were a defective piece of equipment?
I think there's an important distinction there, right? So if there was a failure based upon the installation, the liability would lie with the person who installed it, arguably. Before getting into statute of limitations, statute of repose issues, it's 13 years old. The town certainly does not manufacture any of the equipment at issue here. I mean, it doesn't manufacture the meter, doesn't manufacture any of the piping. So if there's a failure based upon metal fracture, thing of that nature, I don't think that could be attributed to either the town or, quite frankly, to the plumber or any of the other entities that were first sued in this litigation.
Okay, thank you, counsel. Case is submitted.
Thank you, Your Honors.
We're going to take our morning break. We'll be back in about 15 minutes.
All rise.
Okay, we'll move on to case number 5, which is Department of Children and Families versus Mother, number 2023P1454. As I'm sure you're aware, this case is impounded, so please refrain from using the parties' names.
May it please the court, Sherry Krasner on behalf of the mother who is watching this argument on the live stream. We are asking that the court vacate the judgment and remand to the trial court. On the civil side of the ledger, termination cases are the most consequential cases that the courts have to decide because of the liberty interest involved. And here, and I'm not meaning to be flippant or disrespectful, but does this court want to affirm the irrevocable end of a parent-child relationship based on a dozen pages of testimony from a novice worker who had one meeting with the parent? And in fact, I asked the court to look at that testimony, which is the record appendix, pages 11 to 23. And in fact, that testimony and also the cross-examination, as brief as it all was, showed that mother had stable housing, she had an income, she was consistently visiting her child, she had just signed the necessary releases to do a parenting evaluation, and she appeared to be in good control with no apparent mental health or substance abuse concerns. And perhaps you'll respond and say, but what about the documents? This decidedly was not a documents case. There wasn't a single DCF report. The updated court investigation was close to a year old. The only document, contemporaneous document, was an action plan that was prepared a few weeks before trial. That's at record appendix page 324. And if you look at that, mother had complied with many of the things that were on it in terms of having housing, in terms of having an income, in terms of consistently visiting with her child. You may ask, there seems to be an undercurrent talking about domestic violence in this case, but I would remind the court that the two reports that the child was a witness to verbal arguments, both of those were screened out. And that action plan to which I just referred, there are no requirements on that having to do with domestic violence. So from the department's perspective, they certainly weren't suggesting that that was an issue in the case. Of course, I'm skipping ahead and over my first argument that we shouldn't even be getting here because of the due process issue. And I would say to the court, too, that child's counsel did not respond to the argument, the due process violation suggested she's implicitly agreeing that there was a due process violation when mother was constructively.
The appellee doesn't have any obligation to file a brief, so I think that goes too far. But I wanted to ask a question about this. So it seems to me that the real nature of your challenge is to the latter decision, not to keep the evidence open for the mother to come in, because on the motion to withdraw, how was the mother prejudiced by letting counsel represent her during the trial?
Well, first, there was a complete breakdown in the relationship, that no one disputed that. And when there's a complete breakdown in communication between a client and her counsel, that threatens the right to a fair trial. And counsel did try to come in before trial. She marked up her motion to withdraw based on that breakdown in communication several weeks before trial, and the court declined. The court didn't deny the motion. The court simply did not act on the motion. And then at the day of trial, the judge, she didn't apply the right standard. She said, I can't let you out because mother hasn't abandoned the proceedings.
But how did that decision prejudice the mother? Because the alternative would have been the judge would have held the trial with mother completely unrepresented, right? Because she wasn't there.
So there was a certain benefit to mother by having counsel there to register objections and to be an officer of the court. But if counsel and mother have not been able to communicate about what mother's position is at trial, how can you argue that that counsel is effectively representing that mother? And if she's not effectively representing that mother, then that is the prejudice to the mother, not being represented by someone who knows what it is that you want and what you want your counsel to be arguing for.
But this attorney, well, the situations are fluid. A few months before that, there had been a breakdown and it was resolved, correct, with that same attorney?
Correct.
And this attorney was a third attorney, correct?
She was, but I would say, well, I don't know if you wanted to ask.
No, go ahead.
That there's nothing, when the judge denied the motion, there is nothing at all to suggest that the judge had looked at the docket, realized that this was the third attorney. That was not nothing that you can glean from the record to suggest that that is what caused the judge to deny the motion. She denied it because she said, well, your client hasn't abandoned the proceedings, so I can't let you out.
But this judge had been on this matter before, and I believe the judge had discussed that during the last time your client had attempted to fire her third attorney.
Right.
So I think we can infer the judge knew the circumstances. And also, this judge was faced with your client who decided not to appear for trial. So as Justice Shen said, she had a difficult choice to make. If she had let the attorney withdraw, that would have put your client at a significant disadvantage.
Then she should have allowed the record to stay open. Because if there has been this, particularly in this case, where there was a disagreement, they were able to resolve it, and then counsel comes back a few months later, before trial, doesn't wait till the eve of trial, a few weeks before trial, and says, look, we cannot communicate. And she specifically says in her affidavit, counsel, that the due process, this implicates due process, because I know that there's such a breakdown. And so for the judge not to hold the record open for a brief period, no one is suggesting it needed to be a long period of time, but for a brief period of time to let mother come in, explain the reasons for the breakdown so the court could make that assessment.
Do we know from this record what the mother would have said if she'd had that opportunity?
No, we don't. I mean, we know that there was that breakdown, but again, if you don't know, then you don't know if it was, if mother had unrealistic expectations of counsel. I mean, that might have been a reason where the court said, no, counsel can't withdraw, but we don't know at all what those reasons are, and not to hold the record up. And of course, we understand that the interests of the child are paramount in these cases, but this was a case where the child was in a stable placement, had been in that placement essentially the entire time that she had been in care, and that a brief continuance to allow mother to come in and to determine what were her reasons for alleging that there had been a breakdown in that relationship would preserve her rights.
Don't the motions and the affidavits of counsel establish that what was going on was that the mother was not responding to counsel? It wasn't that there was anything substantive that they were disagreeing on. She just simply wasn't communicating.
I mean, it's tricky for counsel always in these cases because counsel, I mean, there's a confidential client attorney relationship, and there's only so much that the attorney can ethically divulge, but she did say that she felt that the mother's due process.
But she says affirmatively in the affidavit, I have been unable to reach her, and she hasn't heard from the mother.
I believe she says that in the first affidavit.
Yeah, and then in the next motion for short notice, she says she got a text from the mother just asking her to withdraw, and in concert with that, the mother refused to attend a prearranged phone consult.
But the prearranged, I believe, was in the first motion. The second motion, she does talk about the difficulty in...
Prearranged is in the motion for short notice.
I'm sorry, I can't hear you.
The prearranged consult is in the motion for short notice, which was filed in May of 2023. So
That was what she filed in support of going forward on the emergency basis and not
Right,
to
right.
nitpick,
So
but in
isn't-
terms of why she wanted to withdraw when she talks about why.
I mean, aren't these documents pretty clear that she's seeking to withdraw because the mother is just not communicating with her?
Because
Period.
mother had communicated to counsel that we can't work together. Something is wrong with this relationship. And again, we don't know if mother's expectations were not realistic. We don't know the reasons why the other counsel had withdrawn. I will say that the first counsel who withdrew, things were going well for mother. They had just filed the motion for review and redetermination, and the child was returned to mother's care. So it doesn't seem like that, although I'm making inferences, but it doesn't seem like that was a bad thing that was happening in that relationship, or an inability for mother to communicate with that counsel. But I think the problem is just how the judge approached it, and thinking that she couldn't let counsel out because counsel hadn't abandoned the proceedings. That it was such a distortion of what the judge was supposed to consider in deciding whether or not to allow the motion, that creates one due process problem, and then the second problem is not holding the record open to just determine what was the reason that mother did not appear. There's confusion with whether the judge also talks about the fact that mother was aware of the proceeding, and there was some confusion because the first day looks like child's attorney had sustained an injury, so the case didn't go forward, and mother also had a visit with the child scheduled for that day, but on the second day, which was really the first day of trial, the judge suggests that the social worker had made clear to mother that trial was proceeding that day, and I would suggest, the specific site is in my brief, but I would suggest that it wasn't particularly clear that the trial was going to go forward on that day.
Can I ask you about mental health and action plan noncompliance, as the judge found, and how those two may intersect, and what your perspective is on the judge's finding that she was deficient with her compliance with the action plan?
Well, there was, again, we just have that social worker who met her once, or had a meeting with her once, and then had supervised a few visits. Her testimony was that mother did not appear to be under the influence. Her testimony was that mother was seeing a therapist. Admittedly, there was some back and forth about mother signing a release to speak to the therapist, but there was nothing in her presentation to the attorney, to the social worker, that suggested that she wasn't in good control of her mental health. And again, we have nothing else. We just have those few pages from the social worker, and I would suggest in a case of this magnitude that, a few statements like that, and again, and why I cited to adoption of Harriet in my brief is because you have to have sympathy for a judge who, here's a trial, we're scheduled for trial, we've got a busy docket, the parent doesn't show up. I mean, it's understandable, but the due process rights that are at stake, it can't be enough if the department doesn't make its case. And that's what this court said 30 years ago in adoption of Harriet, and I think that same holding has to apply here today. And if there are no other questions, I'll rest on my brief. Thank you.
Thank you. I understand you'll be splitting your time, 10 minutes and 5 minutes?
Yes, Your Honor,
Okay.
that's correct. May it please the court, Richard Salcedo for the Appellate Department of Children and Families. With regard to mother's main argument, I would like to point out that the original date of trial was not June of 2023, but in January. And prior to that trial date, there was a pretrial conference in December, on December 14th. Mother actually participated at that trial, that hearing via Zoom, and although her counsel had indicated to the court that she was having serious difficulties communicating with mother at that time, there was discussion between mother and counsel, and the judge understood that counsel and mother would be meeting and hopefully begin to work together. But soon after, the counsel indicated that they had scheduled a telephone conference on December 17th, but that mother failed to show, and that she failed to communicate with counsel afterward. And that resulted in counsel filing the first motion to withdraw, which was heard on the 22nd of December. And at that time, mother failed to show again. There was a subsequent hearing. That original trial date in January was continued. There was a hearing on a joint motion to continue trial in February, and mother failed to show at that hearing as well. So there's a pattern here of mother not communicating with her counsel and not appearing or engaging with the case. So when it came to the second scheduled date of trial in June, counsel again indicated to the court, I'm having difficulty communicating with my client. And at a pretrial hearing in May of 2023, mother again failed to appear, and that's when the motion to withdraw was heard again. And the court was, as your honors have pointed out, was presented with a difficult choice to make. If she allowed the motion to withdraw, mother would be without representation going forward. Mother instead was represented by counsel because of what the trial judge decided to do. It's very much like what happened in Care and Protection Valentina, which is in my or in the department's brief, where the trial judge in that case was presented with very much the same set of facts, where mother failed to provide her counsel with instructions as to regarding how to proceed in trial. And the court pointed out, this court pointed out that the trial judge could have struck counsel's appearance but chose not to. And the decision of that trial judge to continue representation of the parent at that time constituted sound practice and was within the trial judge's discretion, which I would argue we have here. With regard to leaving the record open, I think the trial judge considered the fact that this case or this pattern of mother not communicating with her counsel had been going on for more than 6 months, and the court was also obligated or entitled to consider the child's interests in stability and permanency, finality. And this case had been going on since 2019. By June of 2023, it had been more than 4 years, and the child had been in a pre-adoptive placement since 2021. So the trial judge properly balanced the competing interests, including the mother's right, and the child's rights as well. With regard to the evidence, I would argue that, or submit that, the that there were 28 exhibits introduced into evidence, and there was testimony, and based on that evidence, the court entered 128 findings of fact, none of which are challenged on appeal. And those findings detail mother's lengthy history of parental neglect when she had the opportunity to parent this child, her history of mental health issues and failure to address her mental health challenges through available treatment and prescribed medications, and her most notably very significant history of involvement in domestic violence, both as a victim and the aggressor. The evidence indicates that, and the trial specifically found, that there were numerous incidents between 2016 and 2022, just before trial, involving multiple partners of mother, numerous incidents that resulted in police responses, arrests, and restraining orders. And that pattern continued, like I said, up until the time of trial. All of that evidence taken together clearly and convincingly supported the trial court's conclusions of unfitness and a termination of mother's parental rights. And unless the panel has any questions. Okay. Thank you.
Thank you, counsel.
Good morning, Your Honors. Tamika O'Brien on behalf of the child. Your Honors, the heart of this case is consistency. In this case, mother was consistently missed court dates. She missed 15 out of 21 of the court dates. She consistently engaged in intimate partner violence, not just with her boyfriends, but also with her own mother. There were, in this case, 11 domestic violence responses, and mother had 2 restraining orders against herself. 2 of these incidents were in front of the child. Yes, there were verbal arguments, but they were domestic violence incidents nonetheless. She consistently missed virtual visits. The trial court found that she had missed the majority of virtual visits, and while she was more consistent with her visits with the child while in person, she was often late to those visits. She inconsistently engaged in therapy. In January of 2023, she did not have a primary care physician or a psychiatrist. And considering her mental health diagnoses, that is something that is very crucial. She claimed in meeting with she met with a social worker in May of 2023, and she claimed that she was engaged in therapy, but at that time, she was unwilling to discuss services, did not want to file or sign a release saying that she'd already signed one. She wouldn't provide the name of her therapist. Yes, a lot of this evidence, as the appellant points out, was as this case had rocked on. But there was no intervening change here in mother's behavior. Her behavior and her responses to the department's requests and action, or on her action plan, were just like the responses to the rest of her life. They were inconsistent. Sometimes she would do it, sometimes she wouldn't. And unfortunately, as the court noted in Conclusions of Law 19 and 33, Roman numeral I, and, 2 and 6, as late as a month before trial, mother demonstrated an unwillingness and inability to address her parental shortcomings and make progress to reunification. This is not a situation where anyone's saying that mother does not love her child. The court obviously found that this child benefited from 2 visits a year post-termination, but because mother was unable to ameliorate or fully address and consistently address the shortcomings that led to the removal 2 times of this child, the trial court was correct in finding that this child deserved permanence and the adoption plan as set forth by DCF was appropriate. And for those reasons, the child asks that you affirm the trial court's decision terminating mother's parental rights. Are there any questions? No? Okay. Thank you, Your Honors.
counsel.
Have a
Thank
great
you to all counsel. The case is submitted. Our final case is Department of Children and Families versus Mother et al., case number 2023-P757. And this case, of course, is also impounded, so please refrain from using the parties' names. You must be Attorney Eisman,
Yes,
so
Your Honor.
you're splitting 555?
We are,
Okay.
correct. Good afternoon. May it please the Court, Lynn Eisenman, on behalf of the mother. Your Honor's mother is asking that you vacate the decree terminating her parental rights, as well as the order regarding post-termination and post-adoption visitation between her and the children. Given my time and that my sisters will be making some of the similar arguments that I raised in my brief, I will move right to the issue of post-termination visitation order, unless Your Honors have any other questions for me right off the bat. Okay. So, as we know, this is a mother who was visiting with her children routinely and consistently. She was having visits every other week with them for 2 hours during the course of the case. Once the termination decree issued, then the department reduced those visits to monthly. First couple of visits go well, and then on the third visit, there were some issues that arose. And we've gone through those in detail in my brief. Suffice it to say that those issues arose after the children raised some significant concerns to mom about their care at their residential placement, for the boys, and then the daughter about concerns about her care at her foster home. This was a mother who herself had a history of abuse while in foster care, so certainly these were some significant concerns that she was hearing from her children. And that's what led ultimately to the visit being ended, the police being called. It was not the department who notified mother about these concerns. So these were marks on the children. One of the children had lice. So that was another piece that just added to this, that the department either didn't know that this was happening or hadn't communicated with mother before the visit so that she was aware of what to expect. And unfortunately, things spiraled after that. While I understand the judge's concern in hearing about these events, the solution wasn't to then punish mother by drastically decreasing visits going from monthly to quarterly. The better solution would have been to put in place a system where how notification to mom by the department of concerns would have been communicated before visits, how and when issues would be discussed, things of that nature, because none of those rules were in place prior to the visit that the judge had implemented. And the conditions that the judge put in place don't address the concerns about the miscommunication between mom and the department. It's things like mom will not speak about the court case or the appeal with the children, except that doesn't address those concerns from that visit because the kids have counsel. They know that the case is ongoing. They know that there's an appeal. So those conditions aren't related to the care that the children were receiving and the issues that the children had raised with mom. When the court issued its decree terminating parental rights originally, the judge said that she wanted expert testimony about the amount of post-termination and post-adoption visitation that would be in the children's best interests. That information was never provided by the department's experts. They had 2 trauma evaluators who had performed evaluations of the 3 children. Those evaluators 2 of them only talked about post-adoption contact, not post-termination at all. And the one evaluator who did reference post-termination contact only talked about it having to be reliable, consistent, mom to follow rules. There was nothing about specific frequency. The only evidence before the judge on frequency came from mom's expert, who opined that there should be monthly visits. And I do recognize that the judge gave that expert testimony less weight. I did raise issues about that in my brief. But that was the only evidence that the judge had in front of her about what the frequency should be. So because of all of those concerns, as I said, that drastic decrease in visit frequency for these children who...
As I understand the judge's ruling, her concern was really about that November 22nd, 2022 visit.
Correct.
But the mom's point of view, who I think by this point she was pro se, was it's not fair that father gets more visits than I do.
Correct.
But how can we find that the judge abused her discretion if her ruling was based on the facts that occurred at that visit and not just I'm giving dad more than mom?
So I think it's not to minimize what happened at that visit. It was one visit. The visits before that had gone well. What happened at that visit was the result of these significant concerns that the children were raising about their care at the residential placement and in a foster home. And this was not the first time that these significant concerns had been brought up. For example, the daughter was physically abused in a prior foster home. There were criminal charges against that foster mother. So this is, unfortunately, very sadly, has happened to these children before. So this was a triggering event, certainly. So I think putting some rules around when issues come up, if a child suffers an injury while in care, notifying mom in advance so that she's aware of this and can expect it instead of having to hear it from the children first instead of the department whose custody these children are under.
So there's a motion pending in the juvenile court. Is that motion seeking to reduce the visits, or does it concern something else?
That was a motion that the department filed to terminate visits.
Terminate visits altogether?
Altogether, yes.
Okay.
And that is, the next date on that is in August.
Okay. And that's based on, I'm assuming, intervening events between then and now?
Correct,
Okay.
yes.
Okay.
And if the panel has no further questions, I would just, again, request that the decree be vacated. Thank you.
Good morning, Your Honors. Jennifer DeFeo. I represent the Sons in this matter. At this time, Your Honor, on behalf of the Sons, we are asking that this court vacate the decree. We are going to focus, unless this panel has any questions otherwise, on the best interests of these boys. These children feel as though the termination was inappropriate based on their unique situation. As this court knows in adoption of Nancy, there is 2 parts to termination. One is parental unfitness, and the second is whether it's in the best interest of the children. In the Son's position, there was no reason at the time that the termination occurred for it to occur. The issues between unfitness and best interest should not be conflated. They have to be looked at independently. The best interest analysis wants this court, the lower court, to focus on the specific situations as they exist for the children at that time, and that's in custody of a minor. And in doing so, by looking at the situation, the juvenile court needs to consider the children's needs, affections, and their environment. And that has to be looked at based upon the parent's character, temperament, capacity, and conduct. This court, as I'm sure has read well into the facts, saw that the children, in particular the Sons, had disastrous foster care placements. The older son was 8 when he was placed in St. Anne's after 2 disastrous foster care placements. He stated during his trauma evaluation that he feels mad and sad when talking about adoption. There's nothing in the trauma evaluation that suggests that the older son can or will bond with anyone. other than his parents and siblings. And bonding is very important. The court should consider whether the child has a continuous placement, bonds with any particular caretaker, and his likelihood of being adopted. There's nothing in any report that suggests that. Even the adoption social worker, at the time of trial, found that she couldn't start the recoupment process, in part because of the younger son's ability to be successful in placements or in placements with his siblings. The younger son had 15 disastrous placements. 51 A's were filed against his foster parents. One placement resulted in him being physically harmed. He's currently 10 and a half years old, and he is in St. Anne's as well. The St. Anne's program has provided these boys, without a doubt, with stability. There are counselors who they may be bonded with, but it's not a bond that's going to be a lasting bond, such as with a parent or how the court would anticipate a foster parent. These are fleeting relationships. The counselors are going to come and go. Their teachers are going to come and go. Just like a child in a public school system, they may bond with a teacher, but what type of bond is that? That is not the bond that this court should be considering when looking at whether the children's best interests would be served by the termination of the parental rights.
So the adoption worker testified that she has been successful in the past in finding homes for children with similar level of needs, and the judge credited that testimony. So what do we do with that?
Well, Your Honor, I think you also have to take that in light of the social worker's other testimony, which the judge glossed over, such as troubling facts. Let's not focus on those troubling facts. The troubling facts are the social worker specifically said, I cannot start recruitment yet. Why? Because the children need more time. The children are not ready to be placed. The younger son cannot get along well enough with his sister, which is demonstrated not only in the trauma evaluation, but in field foster placements together, that it wasn't ripe. And that is one of the big issues in this case, Your Honors, is that the best interests did not scream enough in this case. What it screamed is, we are not ready. The children were not ready for this to happen. What this has done is created uncertainty, fear, unpredictability in their lives. The younger son told the trauma evaluator, I've only felt safe at St. Anne's and with my mother. That is a huge telling statement. Where is his mindset? How is he going to walk out those doors if and when at St. Anne's? And we don't know when that's going to be. He could be 18 years old. He could be 22. He could be 12. We don't know. But today what we know is that boy has said, I want to go home to my parents. I don't want to go anywhere else. And he's shown, if I go anywhere else, I am not going to handle it well. And Your Honors, I see my time is up, but I would like to say that the judge at trial transcript 30 stated, unless you find angels that walk this earth, these are unadoptable children.
She said that at the beginning of the trial, and she was referring to all of the cases on her list that day. She wasn't referring to these children specifically.
She was very clear that these children were institutionalized, Your Honor, and that because of this system of institutionalization, which these boys definitely are, that it would take more than just an adoption social worker's statement, in our opinion, that they are placeable. These boys themselves do not believe that they're placeable. And the older boy at 13 and a half is not going to consent, which is going to throw the entire system off because the adoption social worker believes that they should be adopted together, which does not coincide with the reality. The older boy saying, no way, and the younger two not getting along. So again, we are asking that this be vacated and that the best interests of the children dictate that this was not the appropriate decision. And if there are no further questions, I will rest on my brief.
Okay, thank you, counsel.
Thank you.
Good afternoon, Attorney Deborah Dow, and may it please the court, I represent the father who is listening on the YouTube link today. The judge in this case said that she considered 4 factors in terminating father's parental rights to all 3 children: domestic violence, drug use, unwillingness to understand his children's needs, and homelessness. I would suggest to this court that those were all in error. And in fact, the judge contradicted herself at least several times in suggesting that drug use was an ongoing problem. In fact, in the end, she concluded that it was not. The first factor, which the judge seemed to focus on more than the others, domestic violence, I would suggest to this court that that is stale. Father had engaged in services to the extent that domestic violence services were then taken off of his action plan. He engaged in the Strong Fatherhood program, which was 20 weeks long. He also set up a safety plan. Both of those were then taken off of his service plan. We know that father had relationships after mother. So post-2017, there were relationships that were documented and in evidence during this trial. There was nothing to suggest that there was domestic violence in any of those relationships. There was also nothing on father's carry, which is also in evidence, to suggest that there was ongoing domestic violence. As far as the second factor, drug use, again, there was no indication during these proceedings that father was using drugs or under the influence at any time during visits. DCF never requested that father engage in any sort of drug treatment or undergo a substance abuse evaluation. There was also no evidence that father used drugs except for mother's testimony. She revealed that in 2021, she had heard rumors and never personally observed father. And so then after speaking with him, seemed to be satisfied and felt confident that he could parent. That was the only allegation that there was.
Well, the judge's conclusions of law at page 107, and it's conclusion of law 5, didn't focus on anything about the dad's drug use. The judge said that he displays grievous shortcomings that place the subject children at risk of medical neglect and further exposure to trauma. And then it went on to say he's not willing to step up and be a full-time parent. He considers himself a last resort. He lacks an understanding of the child's needs. Her focus wasn't on the drugs in terms of finding what were his grievous shortcomings. So could you talk a little bit about why you say the judge didn't have enough evidence of his grievous shortcomings?
Well, in addition to, and I think you named some, and some I certainly addressed these in my brief as well, medical neglect, for example. There had not been a medical neglect allegation against father since, I believe it was 2014. So there certainly was nothing current to suggest that was an ongoing issue. And those ongoing issues would need to be present in order for the judge to find grievous shortcomings. They just weren't here.
But he wasn't present in their lives for 3 years, right?
He was not. He was not. And that came after.
Isn't that a significant factor that the judge could rely on?
It could be, but in fact, the judge actually found that abandonment was not a factor in this case. That is in her conclusions.
Well, it's different to say abandonment is a legal reason to find a parent unfit versus the judge could certainly find as a factual matter that he wasn't present in their lives, and that's one factor that contributes to unfitness.
And when he came back into their lives, he certainly was engaged and involved. He seemed to offer a calming presence. He never missed a visit. He seemed to understand at least his children's emotional needs and where they were as far as educational needs, to the point that he had unsupervised contact at some point during these proceedings with all of them, and DCF contemplated reunifying not only child 3 with him, but child 1 as well. He had unsupervised contact in his own home with child 2. So he certainly became re-involved and re-engaged to the point where that certainly should not constitute a grievous shortcoming.
Okay.
So I see I'm out of time. I would just, if there are no other questions, I would just ask the court to vacate the decree of termination as to father. Thank you.
Thank you, counsel. I know 5 minutes isn't a lot of time, but you can be assured we've read the briefs carefully. And this is an important case, as all of our cases are.
Thank you, Your Honor.
Counsel, I understand you're splitting your time 10 minutes and 5 minutes?
Correct, Your Honor. Good afternoon, Assistant Attorney General John Hitt for the department in this case. We would ask that the court affirm the decrees and orders of the juvenile court here. In short, mother here has a history of getting violent, and particularly violent when she hears bad news or is faced with challenging circumstances. She has immersed the children in a violent and chaotic environment. She has been regularly a part of that violence, and that has included every time the department has tried to reunify her with these children. All three children have significant ongoing mental health issues, and as to at least one of the children, there's also physical health issues that mother has been very unable to meet, despite repeated attempts to provide action plans that would improve her conduct. Here, the juvenile court correctly entered the judgment dispensing with the mother and father's consent to adopt. The evidence here shows clearly and convincingly that both parents have repeatedly exposed the children to domestic violence. Both parents have repeatedly neglected the children's substantial mental and physical health needs. Both parents have failed utterly to provide the children with stable, safe, and clean housing. Both parents have enveloped the children in a pattern of near continuous chaos. I would invite at this point the court's questions, if any. Otherwise, the department would rest on its brief.
I don't see any questions, counsel. Thank you.
Okay, thank you very much.
Good afternoon. May it please the court. Susan Taylor for appellee child number 2. My client will be 12 years old in October. She has not resided with either parent, since December of 2018. She has spent more than 50% of her life in foster care, and that's not counting the 2 years that she was in foster care from 2015 to 2017. She is going into the 6th grade, and since December of 2022, she's resided at St. Anne's. That placement has provided her with the first case of some safety and stability, something that she never had with her parents. It is not an abuse of discretion for the court to have found that these parents are unfit. Mother suffers from lifelong untreated mental illness and anger issues, long-standing housing instability, and domestic violence with the partners that she has been with. Father, likewise, in domestic violence with mother, when the children were present and involved in those instances of domestic violence. Father also has housing instability. He seems to reside with whatever woman he is with at the time. And his lack of engagement with the children for 3 years. Although that said, I will say that my client is bonded to these parents. She visits with the father monthly. She enjoys those visits. She's communicated to me that she would like to see her father more often, not less often. She also would like to, she sees her mother quarterly. She told me that I saw her yesterday, and she told me that she sees her mother quarterly, and she would like to see her mother more often. Not as often as her father, but she would like to see her mother more often. It was not an abuse of discretion to terminate these parental rights, and I asked the court to affirm the lower court's decision.
Okay, thank you, counsel. Thank you to all counsel. The case is submitted.
Thank you.
That concludes our session. Thank you to our court officer, our timekeeper,